Let's welcome our guest for this hour, civil rights and trial attorney Adanté Pointer. And I want to start there, Adanté. And Michael, you said something that I've been wondering, and I'd love to get your thoughts. And that is the fact that Adam Montgomery is, again, day 2, not in court. He gets the choice every morning. He's refused transport both days. But, you know, you hear what the witnesses, all 3, say he did to Harmony Montgomery, and I have a visceral reaction. I don't like this man at all whatsoever, and it angers me. Is there a point to not having him there so that the jury can't look at him and connect him immediately to the things that are being described on the stand?
I think there is some strategy behind that. You know, certainly some benefit to the defendant not being there in court, because you are going to look at him and see how he responds. And is his response appropriate? Is he teary-eyed? Is he crying? Is he looking remorseful? Is he looking guilty? Those are all the things that a jury would want to see, and looking towards him to see his reaction if he was sitting there in court. The other way a jury could look at this is saying, this guy's a coward. If you didn't do this and you wanted to take this to trial, why are you not here to face this evidence, to face your accusers, and sit here and give us a presence of, I'm innocent, at least innocent until proven guilty, versus an empty chair being an empty soul, which therefore means a guilty, convicted person?
That's kind of where I fall on this thing. It's like, if you're going to stand up in court in his other court case and talk about these are preposterous allegations and I'm not guilty of that, well, then you need to be in that courtroom. And the fact that you're not there, to me, would rub a jury the wrong way. But, you know, if it is strategy, I understand that, you know, you may think that's the way to go, but I struggle with that.
Can I ask you really quickly, does the jury know? Do they say to the jury he chose not to be here today, or there's no comment about that open seat? I don't know how that works.
Yeah, the judge will not say that directly unless one of the sides requests it, and I don't know if they've actually requested it or not. If I were the defense, I wouldn't request it. If I was the state, I would want to request it.
Okay, that's good information.
We'll have to find out if actually they're doing it in this case. Adanté, quickly, I want to talk about the assault charge in this case. We had a lot of testimony about it today. It was really ugly testimony, but it really highlighted the importance of that charge in general. There was a lot of argument as to whether it should be allowed in the case. Of course, the defense wanted it out, state wanted it in, but when you think about it from the state's point of view, getting that charge in is so important, because it really, if this defense, and they probably anticipated they would try to point the finger at Kayla, but when you already have an assault in front of this jury that really mirrors what is claimed to be done to her that took her life, I think that's so important, especially in light of the fact we know the defense is going to say Kayla was responsible.
Absolutely. You know, you don't have a body here, so you're not able to use the corpse or the body and say, this is what happened, this is the physical evidence. So now you have to kind of, you know, I don't want to say stack the deck, but you have to build your pyramid of evidence based upon a foundation of, well, what do we know about the way he treated her? Where we do have witnesses to corroborate, or at least to come into court and say his course of conduct or behavior with his daughter. And it's devastating that the people who are, you would think, closest to him, best friend, uncles, things like that, come into court one after one, get on the stand, point at him and say, this is what he did to this beautiful young girl. This is what he did to his own daughter. That lends itself easy for a jury to then listen and say, hey, despite us not having the body, despite us not having, you know, that type of physical evidence, we see what type of person and we see the treatment of which you had to your own daughter. It's a course of conduct that I think is very damning and devastating to the defense's case.
You know, you hear about what happened to her, Michael, and then you see those pictures of her, and she's smiling and beautiful, and the resilience of kids, any kid that should have to go through that.
You know, I hate to say this, but when you think about a child in that situation where they have to come home every day or be in a house with someone that she clearly probably feared, it just breaks my heart, you know, because they really, you know, you're a child and these are the people that are supposed to be taking care of you, but yet you have this fear of that person. I can't imagine what that must be like.
I can't either. And the jury listening probably feels the same way. All right, coming up next, we're going to head back to Tennessee for the murder between mothers trial for Annette Harvey.